All right, now let's look at the advantages and disadvantages of arbitration. Now that we've explained what it is, let's talk about what are the advantages. And the first advantage, as with mediation, is that it's a time saving. Now, it's not going to be fast as a negotiation, and it's unlikely to be as fast as a mediation, but it is still going to be quicker than litigation. The process of arbitration is going to occur much faster than if you filed a lawsuit. And remember too that once the arbitration is final, then the case is over. It's not like a lawsuit where you could appeal or where the other party could appeal. So there's definitely a time-saving factor when it comes to arbitration. There's also a money-saving factor. Again, not going to be as inexpensive as mediation, but certainly could be less expensive than litigation. There's going to be fewer, and this has a lot to do with time. Because the matter can be resolved more quickly, that gives fewer opportunities for the payment of attorney's fees and expenses. So saving money for sure. It's flexible. When we were talking about litigation, we said that litigation, one of its disadvantages, there's all these rules that apply, and those rules are the rules regardless of whether you and the other party even want to follow those rules. They're inflexible. But in an arbitration, the parties can set their own rules. And those rules are very flexible. Whatever the parties agree to be the rules, they become the rules. Expertise is a huge advantage. I said that the arbitrator, our arbitration panel, will almost certainly have expertise in the area of the dispute, meaning you as a party involved in the dispute do not have to spend time and money educating the arbitrator. Now, this is the exact opposite of the typical jury system, and we'll talk about juries a lot in the next lecture. But of course, in a jury matter, you have 12 people who are likely to know very little about the subject matter of the dispute. And therefore, in the typical jury trial, half of your time and energy is going to be involved in educating the jury and the judge as well. But in an arbitration panel or an arbitrator, you're going to get someone who already knows that system, that industry. There are other advantages as well. Arbitration it allows for neutrality. We're going to have a neutral arbitrator. I mentioned arbitration panels, and the way arbitration panels usually work is there's 3 arbitrators, and the party seeking relief will choose an arbitrator, and the other party will then choose an arbitrator, and then those 2 arbitrators will choose a 3rd arbitrator to act as a neutral party. So neutrality is a huge part of the advantage of arbitration. This is not like where it's a local elected judge and you're going to see that judge again. Arbitration has the advantage of neutrality. It can also be confidential, meaning if there is a bad result for you in litigation, that bad result is going to be public knowledge, and meaning it can, at a minimum, be used against you in settlement negotiations, but even more likely is that can become binding precedent, meaning that becomes the law. The bad result becomes the law. In an arbitration, everything having to do with the arbitration, not just the dispute, but the award as well, is confidential. It's only held between the parties and the arbitrator. So confidentiality is another reason that businesses like to choose arbitration. I mentioned earlier that arbitration awards are enforceable, and they are in some ways more easily enforced than a litigation award, because most courts do not have the power to look at the actual conduct of the arbitration. If you are unhappy with an arbitration award and you go to court and say, look, this arbitration wasn't fair, the court is not going to be able to look at whether it was fair or not. All they can look at is there an arbitration award? And if there is, the court must enforce that award. Another big advantage of arbitration is there is the availability of institutional help. There are arbitration companies that specialize in arbitration. So if you are involved in a construction dispute, for instance, there are arbitration companies that focus on construction disputes, meaning you don't have to go hire a lawyer who's going to have to go do the research of how to handle this dispute and then contact you. You have that institutional help available to you before you, and available directly to you without the necessity of a lawyer. Arbitration also allows, because it's quick and it's binding, it has the effect of mitigating hostilities, meaning the parties can reach a decision quickly. A final decision is very quickly, and they can go back to doing business with one another. So arbitration tends to mitigate hostilities because it's so easy to go back to business, because you have a dispute, you have a final decision, and then you move on. And so we find that with companies, arbitration allows the companies to resume a normal business relationship much faster than litigation. Now, there are disadvantages to arbitration as well. And probably the greatest disadvantage is this idea of if there is a disparity in the bargaining powers of the parties, meaning one party is powerful, the other party has to take whatever the powerful party insists. And this is the case in, for instance, consumer arbitration. You know, you are not allowed to negotiate the terms of arbitration with Verizon when you sign a cell phone agreement. There's a huge disparity. And what that means is that if that disparity exists, it is possible for unfair procedures to be put into place. That you, as a party with much less bargaining power, cannot renegotiate the arbitration agreement to allow for a fair procedure. So arbitration is not always magical. Arbitration seems to depend on two sort of equal parties. Confidentiality, which we said was an advantage, could also be a disadvantage because you don't know how most disputes of this type are resolved. Meaning when you go to arbitration, you have very little guidance on what this particular arbitrator is going to award or not award, and because it's all confidential. So we don't know what this arbitrator has done in the past, and we don't know what this particular case will be worth in this particular arbitration. It is difficult to gauge the downfall of an arbitration, meaning because we are lacking knowledge, we have less knowledge, it's difficult to determine how badly the arbitration could work out. The primary disadvantage, too, for many parties is there's no appeal. So the binding nature of arbitration is dangerous. If you have an arbitrator that rules heavily against you, you have very few options. You must accept that award because there is no appeal. Remember, it's binding. So you will undoubtedly, sometime on your test or on your writing assignment, have this issue of the binding nature of arbitration. A bigger scale idea of a disadvantage of arbitration, not so much for the particular parties involved, is that if we shift everything to arbitration and all those arbitrations are confidential, that is going to prevent the free flow of information and expertise. And so this is a thing that that many scholars and industry professionals have been concerned about with the growth of arbitration in the United States, for example, is that we are going to prevent the free flow of information, which we have enjoyed in the past. If we have access to numerous appellate decisions regarding a certain matter, then we know that's the standard. With arbitration, everything gets shifted to arbitration. We're not so sure about that.